I'm Ben Meiselas from Legal AF, joined by our co-host, Michael Popok. We got to discuss this truly dangerous and horrific ruling by the Supreme Court. They reached multiple dangerous and horrific rulings on Friday. This case is called 303 Creative LLC versus Ellenis. It was a 6-3 decision. Neil Gorsuch wrote for the majority. Justice Sotomayor wrote for the dissent. The 6 radical right justices all joined in that opinion, and the 3 Democratic appointed justices all joined Justice Sotomayor's dissent in this case. Justice Gorsuch, writing for the majority, found that there is under the First Amendment right of free speech, that a business has the right to discriminate against, in this case, a hypothetical gay couple, if it goes against the business's religious beliefs or closely held religious beliefs. That under the First Amendment, if a state, in this case, it's the state of Colorado where this took place in, had passed a law that prohibited businesses from discriminating against people on the basis of race and ethnicity and sexuality, that such a law would be unconstitutional, a violation of the First Amendment, according to the Supreme Court decision, because it would prevent somebody who wants to speak discriminatory thoughts from being able to speak that way. I want you to break this down, Popok, but the first thing I just want to talk very briefly is the procedural history. This started in a district court in Colorado, went to the 10th Circuit Court of Appeals, which both rejected that nonsense that I just said that the Supreme Court ultimately held. And in this case, this entity, 303 Creative LLC, it was purportedly created by someone named Lori Smith. And the idea was Lori Smith claims that she was going to be creating a business that would make websites for couples that were engaged and about to get married. The thing is, Lori Smith never actually created a company. She never made a website before, yet she said she was in a business of making websites. And then as part of her lawsuit also, she claimed that her business, where she's never made a website before, her website business that's never made a website before, she claims she got an inquiry from a gay couple, from somebody named Stuart, who wanted her to make a website for them. Here's the thing, though. When the media tracked down this individual named Stuart that's listed in the lawsuit, Stuart said he never contacted them. Stuart said he's not gay. Stuart's been married for 15 years, and Stuart never reached out to them. So what seems to have occurred here is a business that's non-existent or theorized, led by someone named Lori Smith, filed a lawsuit saying that she didn't want to make a website for people who weren't real, based on either a doctored email saying that this person wanted a website being made, or just it never existed at all. And this way, Lori Smith and the right-wing groups that actually were the ones pushing this agenda, the federalist agenda that's being pushed here, can claim, oh, there's an injury here and we need pre-enforcement. We need the courts to intervene, pre-enforcement, because if Lori Smith has to make a website as part of her business for this gay couple, Lori Smith said, that's going to violate my closely held religious Christian beliefs, and I don't want to make them a website because I think that that goes against the word of God. Company didn't exist. The people didn't exist who sent the email, yet the Supreme Court heard this case. So for me, as someone who's been practicing law over a decade, everything I've learned in law school, it is such an atrocious concept that doesn't even takes place. And then the ruling is so horrific. Break it down, Popok.
Yeah, and then we're back to this concept of the weaponization of standing. There was no standing, and in order for a court at the Supreme Court level to issue a ruling, first and fundamentally, there has to be a live case or controversy. That's a term of art in constitutional and other law, which prevents, it used to prevent until this 6-3 super right-wing majority got in place, it used to prevent courts from making what's called advisory opinions. If we ever had a live case in front of us and it had these kind of hypothetical facts, this is how we would rule. They're supposed to rule on real people having real life issues that rise to the level of a constitutional challenge before the Supreme Court, which is a court of limited jurisdiction, uses its tremendous powers in our co-equal branches of government. That has now been thrown out the window by this right-wing Supreme Court. They don't seem to need a plaintiff or defendant or a party at all. They just reverse engineer. They have an agenda. They are legislating from the bench. We see it here in this new law for the first time in Supreme Court history, which is going to allow a business that accepts dollars in public commerce, a public accommodation company, not a private club. Private clubs can discriminate all they want, frankly. It's disgusting, but they can discriminate all they want. That's why there's golf clubs and other men's clubs that don't allow women, that don't allow Jews, that don't allow blacks, even today at this date in 2023. But a public business that takes money from the public commerce, right? That, before today, never could discriminate against somebody based on First Amendment, not even religion. First, this court, based on the ruling by Justice Gorsuch, who wrote this opinion. Alito having written all the other terrible ones this term, starting with the abortion decision with Dobbs, Roberts having written the one that overturned Joe Biden's attempt to help the little person with their student loan debt. Now Gorsuch, who normally in the past had been sort of more pro gay rights than the other right-wing MAGA. Let's just put it that way, which is not saying much, by the way, but he has like presided over gay marriages before. So we thought, all right, well, maybe if he ends up being in the majority and maybe writes the opinion, it won't be so bad. Wrong. He took this made up, conjured up, phony website business, which means they should not have ruled on this at all. Pointed to a series of stipulated facts, which is what it sounds like, between Colorado and its agencies involved with making sure there's no discrimination in public accommodations, hotels, motels, restaurants, places that you would walk into, website designers, that type of thing. And said, well, they stipulated that she has a business. I'm not sure that's even true, or that was the stipulation. She makes websites, which is not true, but she's about to do it for wedding websites. Okay. And that is a First Amendment expression because they've already stipulated that her creative essence is going into the website, and therefore it's a reflection of her. And this is state compelling her to express herself in a way that is against her beliefs, which in this case, the belief that the marriage is only between a man and a woman. So you have the religious thing, but you have Gorsuch using, this is First Amendment pure speech, and a state trying to compel somebody to say something that they don't want to say, which is, I support gay marriage. By the way, whoever thinks that the vendor that's being hired endorses the thing that they're being, when I hire somebody to paint a logo on my building, so the painter who's expressing himself creatively because he's got the paintbrush, he's endorsing my law firm because he's painting my firm Popok Law on the side of the building. I mean, this is ridiculous. But we have the problem, Ben, of the butcher, the baker, and the candlestick maker. And we had that 5 years ago, before Legal AF, before you and I got together doing these kind of hot takes, where the Supreme Court just 5 years ago, in saying that a baker was creative and they could deny baking a wedding cake for gay people because somehow that was suffused with artistic expression. But they also said that in public accommodation world, they couldn't envision a world until that they would discriminate. They would discriminate based in a public accommodation. And now 5 years later, now that they got the numbers, this right-wing Supreme Court says, no, we're okay with it, which means based on this ruling, which will continue to, it's 75 pages, we'll continue to analyze and do hot takes and do it on our Legal AF podcast together. But based on this, if my religion or my freedom of expression is I don't believe that Black people should go to college, or I don't believe Jews should be bankers, and somebody comes in and says, hey, I want to buy a poster for my buddy, just got a big new job in financial services. What's his last name? Goldberg. Sorry, I'm not doing it. What do you mean? Well, I'm not doing it. And based on 303 Creative, I don't have to do it because I don't believe Jews. I think Jews control the banking system in the world, and I'm not going to celebrate what your buddy just accomplished at his financial services company. Or the Black person graduated college. My mom just graduated college. I want to have a website to celebrate. No, I'm not going to do that. I don't believe Black should go to college. Where do you draw the line? This right-wing majority lives in a dystopian world of their own making. And this is the reality that's going to happen. And they don't care what they've done to affirmative action, what they're doing to people now constitutionally being able to discriminate. Do they think good things are going to come out of this? When it's not the website designer, when it's some, let's be honest, some redneck somewhere in one of these states, and they don't like the looks of somebody. I told you before this podcast, Ben, we just had a report earlier this week where a person who's transgender went to a pharmacy, CVS or Walgreens, I don't remember which, and the pharmacist refused to dispense medication they need to support their, being transgender because it was against his religious beliefs. That's the world this Supreme Court is creating, and we have no counterweight to it. And the three small d democratically appointed Supreme Court justices they're powerless to do anything about it, despite the vociferous counterbalance weight in all of their dissents. In this case, Sotomayor in dissent. They're great. They're eloquent. They bring tears to my eyes. But she's lost 6-3 another decision. And you've got the Supreme Court right wing poking a stick in the eye of the three, because of course they see the dissents before they publish their majority opinion. These things, we've talked about it before, they circulate in caucus and between the clerks. So they all know. And so they like to anticipate the argument. And so they say, well, the dissent's argument. And the way they poked the dissent this time is they said, we're just talking about First Amendment expression, pure First Amendment expression. And the three people in dissent, which is Kagan, Sotomayor, and Ketanji Brown Jackson, 5 days ago, literally 5 days ago, they were fine when we used the First Amendment to stop a series of stalking laws and criminalizing stalking in a certain way. But now 5 days later, you don't like the fact that we're using the First Amendment to allow people to discriminate against whomever they like. And the answer to that is right, because context matters. And that wasn't a public accommodation statute. That was a criminal statute and got to the limits of First Amendment. And this is now I'm so tired, Ben, of you and I having to start a podcast or a hot take by saying, for the first time in 50 years, a constitutional right has either been eliminated in the case of Dobbs and abortion, or has been now a permission slip has been passed out to allow for discrimination and public accommodation for the first time in the history of the U.S. Supreme Court.
It's not just us on the podcast. The Supreme Court justices in the dissent have to say that. This is directly from Justice Sotomayor's dissent in 303 Creative LLC versus Elenis. Today, the court, for the first time in its history, grants a business open to the public a constitutional right to refuse to serve members of a protected class. Specifically, the court holds that the First Amendment exempts a website design company from a state law that prohibits the company from denying websites to same-sex couples if the company chooses to sell those websites to the public. The court also holds that the company has a right to post a notice that says no wedding websites will be sold if they will be used for gay marriages. She goes on to say in the dissent, A business open to the public seeks to deny gay and lesbian customers the full and equal enjoyment of its services based on the owner's religious beliefs that these same-sex marriages are false. The business argues, and a majority of the court agrees, that because the business offers services that are customized and expressive, the free speech clause of the First Amendment shields the business from a generally applicable law that prohibits discrimination in the sale of publicly available goods and services. That is wrong, profoundly wrong. As I will explain, the law in question targets conduct, not speech for regulation, and the act of discrimination has never constituted protected expression under the First Amendment. Our Constitution contains no right to refuse service to a disfavored group. And you think about it, what the Supreme Court is now saying in the majority, and here Justice Sotomayor is calling them out, is that the act of discrimination is a form of protected First Amendment speech. That's such a dangerous, dangerous precedent. I want to do a broader hot take with you, Popok, on all of these Supreme Court decisions that have been handed down, from students for fair admissions versus Harvard and North Carolina, which prohibits diversity to be used as a factor in the admissions process. We'll talk more about 303 Creative. We'll talk about the holding in Biden v. Nebraska, where the 6-3, these are all 6-3 decisions, where the MAGA Republicans struck down Biden's student debt relief program, and more. But appreciate you sharing your thoughts here, Popok.
One last comment to end it. There's a museum in Miami Beach that has posters from the 1940s and 1950s of public accommodation places, hotels and motels on Collins Avenue in South Beach, which literally said, "No Jews allowed." No Jews allowed. One hotel actually advertised in a local newspaper, and I'm not making this up, you can look it up, the following slogan for their motel: "Always a view and never a Jew." Based on the decision that was just rendered by Justice Gorsuch on behalf of the 6-3 majority, we're going to see signs like that all over again. And people are going to be able to cite to 303 Creative as the basis for discriminating against people because they don't like them, because they're racist, because they're bigots. That is the world that this Supreme Court has just created.
Horrific, horrific stuff, but we got to talk about it. And at the end of the day, it's, you got to vote. You can't let, for anyone who allowed Trump to get into office, that, well, you know, every candidate's the same. Sorry. This is directly related to Donald Trump picking 3 radical right, extreme Supreme Court justices, because you go back to precedent even from 2016. And this Supreme Court's overruling all of that precedent. So we'll talk about that more in another hot take. I'm Ben Meiselas, joined by Michael Popok. Hit subscribe on our YouTube channel, and make sure you also subscribe on the Legal AF podcast. New Legal AF podcast will be live on the MeidasTouch network Saturday at 8 Eastern, 5 Pacific. Have a great day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.